Good afternoon. This is the Farrar's Building Annual Personal Injury Law Update. Welcome. I'm David Roderick, and this is some information and contact details for me on the screen. The slides that I'm using will be sent out to you by Kelly, our marketing manager. And you'll notice that there's a Q&A button at the top of the screen or bottom of the screen for you, perhaps. So please write your questions rather in there. If I can answer them in the time that we've got, I shall do. But I'm more than happy to pick up questions and respond by email or telephone call with you afterwards. As in previous years, what I intend to do is divide the talk into developments which apply across all areas of PI law, and then we'll move on to case law updates in particular practice areas. And in respect of general developments, there have been further updates in the recent line of cases from the Supreme Court and the Court of Appeal concerning secondary victims and vicarious liability, and also two interesting cases dealing with the modified tests for proving causation. So we're predominantly going to look at those. As to specific practice areas, we'll look at an interesting employer's liability case and an RTA insurance law case, and then some public liability cases, just finishing with what's really a practice and procedural authority, but appropriate mostly to PI concerning surveillance evidence. So let's begin with secondary victims and the case of Young and Downey. The decision concerns really how a personal injury claimant qualifies as a secondary victim. And it's another important case in this line of cases under this general principle, following on from the Supreme Court's decision in Paul and the Royal Wolverhampton Trust of this time last year. And Young and Downey specifically concerns what witnessing the harm to the primary victim must entail. So I emphasize the word witnessing in the sense of understanding what has been perceived. The facts of the case were these. The claimant's father was a soldier who was killed in the IRA bombing of Hyde Park in 1982, and the defendant had been found liable for that as a joint tortfeasor for an unlawful killing, but hadn't played a part in either the liability or the assessment of damages proceedings. And part of the claimant's claim, as well as a Fatal Accident Act damages, was a personal injury damages claim for the psychiatric injury that she said she suffered as a secondary victim. And the quite fine details of the factual basis of that claim were important. At the time of the atrocity, she was 4 years old, 4.5, I think. She saw her father leave the barracks. She heard the bomb go off, and then she saw other soldiers return to the barracks covered in blood and injured, embedded with nails and such like. And then she said to her mother the words, "Daddy should be coming now." Tragically, her father didn't ever return. So did those features mean that there was a sufficient proximity for her to claim successfully as a secondary victim as a witness to the incident or its immediate aftermath? And at first instance, the High Court judge held that an essential ingredient of that type of claim, one of the control mechanisms in secondary victims' claims, hadn't been satisfied. Namely that the claimant couldn't be said to have witnessed the incident or the aftermath if she had not appreciated and fully understood that her father had been or might have been involved in the explosion. And in making such a decision, the judge rejected the claimant's expert psychiatric evidence that the claimant had indeed feared for her father's involvement and had sought reassurance about him returning. And that expert psychiatric evidence, of course, hadn't been challenged by the defendant, who played no part in the trial. The expert evidence had been that the claimant wouldn't have appreciated it was a terrorist bombing, but would have appreciated that there had been a problem, that she'd been frightened about that problem, and also that the words "Daddy should be coming now" wasn't to be interpreted as indicating that she expected that was a fact that was going to occur, and thus she had no fear or no inkling that her father had been involved, but rather it was a question. and she was seeking reassurance that her father would in fact be coming. The appeal was advanced on the basis that, firstly, it was wrong to import that freestanding requirement that a claimant's got to show an appreciation that the primary victim was a particular person. And the second ground of appeal was it was wrong for the judge to have rejected the expert evidence and substituted his own view that a 4-year-old would think differently from an adult and would not have appreciated that her father had been involved without actually seeing that her father was involved in the trauma. So, dealing first with the uncontroverted expert evidence point, this, of course, will ring a bell when we think about the case of Griffiths and Tuohy in the Supreme Court. Should the judge, in principle, have been able to reject a critical part of the expert's evidence when it had been challenged by the defendant? And the Court of Appeal decided that to achieve fairness and justice, the judge was certainly entitled to ask for the expert to be called to give evidence and to question the expert himself. But the judge wasn't permitted to then allow his own inexpert opinions about the mental capabilities of a child influence his evaluation of that expert's evidence. And the Court of Appeal had said that, in fact, it wasn't even clear from the transcript that the judge had put his own opinion and conclusion to the expert for the expert to comment on it. Dealing with the secondary victim principle, the Court of Appeal reiterated that the control mechanisms from Alcock remain the touchstone. And as we will remember, they require a close tie of love and affection between the claimant and the primary victim, sudden and unexpected shock that makes the injury occur. Thirdly, physical proximity at the scene or the immediate vicinity or aftermath of the scene. And then fourthly, that the injury arises from the direct perception of witnessing that death or danger or injury. And the trial judge had held that it was an essential component of those control mechanisms that the secondary victim has an appreciation that it's a loved one who's the primary victim. And the Court of Appeal held, or they were very resistant to introducing new and even tighter requirements to proximity beyond what's already been explained in Paul, and held that the judge was wrong to introduce that new and separate requirement. The Alcock/Paul test is already a very restrictive one. Of course, there's a policy underlying secondary victim claims, which is generally the law is opposed to granting a remedy to a third party for the effects of the injury that's sustained by someone else. But the Court of Appeal did hold that it was correct that injury to the secondary victim must arise from that secondary victim witnessing the harm or the danger to the primary victim and appreciating that it was harm and danger to the primary victim. So if the secondary victim doesn't witness something in the sense of having an understanding of what was going on, then the duty can't arise. So the 2 points slightly come together on the appeal. If the substituted judge's opinion was allowed to stand, the opinion being a 4-year-old would not be able to conceive of such harm or danger to a person, then the claimant wouldn't have satisfied the test. But the expert evidence was the opposite, that the claimant in fact did appreciate and have an understanding that there had been danger to someone. Next is the decision in relation to vicarious liability, and it's J.D. Wetherspoon's and Berger. The most interesting point in this case concerns stage 1 of the vicarious liability analysis. That's the being in employment or akin to employment test, the relationship between the defendant and the tortfeasor. And essentially the ratio of this case is that in assessing what might be akin to employment in a relationship, the court should avoid elevating factors that are inherent in the provision of an independently contracted task into features that then justify the imposition of vicarious liability. What did that mean in practice? In this case, the claimant had been injured when being restrained by what are now called door supervisors, but bouncers as we might think of them. and outside the Wetherspoons pub. The door supervisors were employees of an independent contractor, RS, and that contractor was retained by Wetherspoons under a general security services agreement. And on the one hand, the agreement provided that RS would be responsible for directing, managing, and controlling its employees. RS had to have employers' liability insurance. RS provided Wetherspoons with indemnities for liability arising out of the door supervisor's acts or omissions. On the other side of the coin, Wetherspoons had the power to remove a door supervisor if there had been a breach of the agreement, could specify what the door supervisors were supposed to wear, and could require them to meet a whole host of other standards in the performance of the contract. So in relation to the proper application of stage one, as clarified in Barclays Bank and various claimants, which no doubt people will remember, that the fundamental distinction is that there's no vicarious liability where the tortfeasor is a true independent contractor. And the question that has to be asked is the tortfeasor carrying on business on their own account, or are they in a relationship that's like employment with the defendant? And critically, the services agreement explicitly stated in this case that RS retained its control over its employees, and there wasn't evidence that Wetherspoons had a direct comparable control over employees. What they were allowed to do was set standards for the service that they wanted supplied. And the factors that had been relied upon by the first instance judge, they indicated interaction and control by Wetherspoons on site, telling the door supervisors what they want to happen, but they were more accurately to be found to be factors that were consistent with a business engaging a specialist independent contractor to perform specialist services at the business's premises, but dictating the way in which they wanted it done to the extent that it had to meet a certain quality. So the decision clarifies contractual arrangements don't automatically create relationships akin to employment, even though those contractual obligations might include operational integration, might include some degree of control over service standards. So it's a further useful case in relation to fortifying the independent contractor defence and avoiding vicarious liability finding. The next two cases, just as a sort of a general overview of the approach to them, they concern proving causation. Now, of course, we all know the basics that ordinarily we prove causation by showing on the balance of probabilities that but for the breach, injury wouldn't have been suffered. But firstly, where injury is caused by the cumulative effect of a tortious and a non-tortious agent, we can modify the test. Causation can be proved by showing that the breach made a material contribution to the injury. And in cases that are presently confined to mesothelioma and lung cancers, a further special rule of causation applies, where if it's known that the claimant was exposed to the risk of inhaling asbestos or some dust that's carcinogenic as a result of the negligence of the defendant, then the defendant will be liable if they can be shown to have materially increased the risk of the claimant contracting that disease. And that's the material increase in risk exception to the usual causation rule. And that's the exception that Johnstone and Fawcett's garage focused upon. And in particularly, it focused upon the permissible methods of measuring materiality of an increase in risk. What does a material increase mean? The facts of the case were that Mrs. Johnson alleged that as a result of being employed in a garage, working in an office outside the workshop space for about 7 years in the 1980s, that she was exposed to asbestos such that there was a material increase in the risk of her having developed mesothelioma. Now, breach was admitted in respect to the processes that the garage had used to blow out dust and asbestos from the brake and clutch parts, which contained asbestos at that time, thus creating clouds of dust in the general environment. But causation was denied. And After determining the conflicting expert evidence, the trial judge concluded that there was an increase of 0.1% or less in the risk of the claimant developing mesothelioma. And the question was whether or not that was material. What constitutes a material increase in risk? Well, in the case of Zgonec-Rozej, Lord Phillips had sort of concluded that you've got, on the one hand, to be more than de minimis in the increase in risk, but it's not the case that an exposure would be found immaterial if it didn't at least double the risk. And since then, there's been a reluctance to determine in cases a quantitative figure as to what would constitute de minimis. It's certainly in the context of mesothelioma. And so in Johnstone, what the court had to do was address the competing methodologies for determining that material increase in risk. And on the one hand, the claimant appellant proposed an exposure risk approach, equating risk increase with exposure increase. So, for example, the increase in risk in this case was material because it was said that the deceased's exposure to asbestos fibres over the course of her life was materially increased by her exposure while she was working at the garage. And you could calculate that increase as between 2 and 4 and a bit percent. The respondent's approach, which was ultimately adopted by the judge, was a direct risk assessment approach. So comparing the risk from the specific exposure at the garage against the background environmental risk at the time. So looking at a whole host of evidence, a range of evidence and data sources to estimate directly the increase in the risk that was caused by the exposure to the asbestos dust at the period of working time at that particular place. Interestingly, the respondent had also proposed an absolute risk approach because they had medical evidence that the risk of contracting mesothelioma from working at that garage would in fact have been medically insignificant. And so the decision overall endorses the direct risk assessment approach when it's properly applied. So it rejects the more simple exposure risk equation, and it rejects the quite harsh absolute risk approach, the latter one would make any exposure automatically insignificant if it could be said to have been medically negligible. And the decision effectively establishes that a host of expert evidence, epidemiological evidence in particular, is necessary is likely to be very necessary in mesothelioma cases. Caution about the case, though, it is expressly stated in the judgment that it's not validating that the direct risk assessment approach is going to be generally across all cases the valid and appropriate method. But whether or not it will be dependent on the evidence of many experts. Accordingly, and regretfully for the claimant, the increase of 0.1% in this case was such a small increase that it didn't satisfy the test of materiality. And the second recent authority on causation, Zgonec-Rozej, concerns the other exception to the ordinary rule of causation. So it concerns materially contributing to the injury. And it reiterates effectively the rule that where factual causation can be determined on a but-for basis, then the doctrine of material contribution doesn't arise. The facts of Zgonec-Rozej were it's a Fatal Accidents Act claim rising out of the tragic suicide of an eminent international criminal law silk, who at the time was a voluntary psychiatric inpatient under the care of the defendant. The deceased had come back into practice in London from practicing in The Hague and had experienced sort of anxiety about that and sleep disturbance, and had been diagnosed with a bipolar affective disorder by Dr. Pereir. And the deceased's admission as a voluntary psychiatric inpatient really unfortunately coincided with Dr. Pereira going on leave for about 3 weeks. The trial judge found for the claimant in relation to breach, including breaches in giving a sufficient enough handover to the separate doctor who was going to supervise during the leave period, a Dr. Bakshi. And there was a breach in relation to delay in arranging psychotherapy. But despite those findings of breach, the judge dismissed the claim on causation grounds, concluding that there was insufficient evidence that the breaches caused or contributed to the death. And that was critically because, in relation to the findings of fact, there was an evidential gap. There was an absence of evidence as to Dr. Bakshi's clinical decision making. And again, regrettably, that probably resulted from the fact that the claimant had made settlements with other potential defendants, including Dr. Bakshi. So the trial judge wasn't in a position to determine whether failures in the care provided by Dr. Bakshi were attributable to Dr. Pereira's breach in respect of the insufficient handover, or whether they were attributable to Dr. Bakshi's own independent shortcomings. And that evidential gap made it impossible to establish that causal link between Dr. Pereira's inadequate handover and subsequent harm. The important general principle to extract from that is that the case clarifies the scope of a material contribution doctrine that Bailey and the Ministry of Defence established. It reinforces that. It's not particularly new, but it reinforces that material contribution is not an alternative to but-for causation to assist a claimant. It applies only where medical science can't establish but-for causation, but where it can establish that the negligent cause contributed more than negligibly to the injury. But importantly, where but-for causation can be determined either way, for or against the claim on the balance of probabilities, then the doctrine of material contribution doesn't arise. And in Zgonec-Rozej, causation, of course, could have been determined either way on the balance of probabilities with the evidence. It was simply that there was an evidential impossibility in the claimant satisfying the but-for causation test. There wasn't a scientific impossibility of doing so. Um, So let's move now to recent decisions in specific practice areas. And firstly, a case in relation to employers' liability, Chuhan and Dechert. The claim concerned the statutory duty under the Employers' Liability Defective Equipment Act of 1969. And again, as we all know, that statutory duty is not affected by the Enterprise and Regulatory Reform Act of 2013 and the removal of civil liability for breaches of health and safety regulations. And the point of the case is really what can be regarded as equipment for the purposes of making a claim under the 1969 Act. And I acknowledge immediately that this is only a county court decision, but it's quite useful because there's a scarcity of authority on this point post-error. Factually, what happened, the claimant is a solicitor employed by the defendant, and she sustains a head injury when the top of a door handle, which is attached to a fire door in her workplace, just becomes detached as she pulls it. And she claimed under the 1969 Act, alleging a defective door for many reasons relating to the bolt that secured the handle to the door. She didn't rely on any common law negligence claim. Section 1.1 of the 1969 Act provides that where an employee suffers personal injury in the course of employment in consequence of a defect in equipment provided by the employer for business purposes, and the defect is attributable wholly or partly to the fault of a third party, the injury is deemed attributable to negligence on the part of the employer. So the claimant argued that the door was an article or a chattel that was provided by the employer in the course of its business, and therefore covered by the 1969 Act. The defendant's case was that such a door couldn't be equipment for the purposes of the statutory definition. And so effectively that question became the preliminary and ultimately determinative issue in the claim. And a key limb of the defendant's argument was the principle that the health and safety regulations should be construed so that they didn't overlap one another unless it was clear on statutory and regulatory interpretation that they were intended to overlap. So to illustrate that in the context of this case, we know that doors fall squarely within the workplace health, safety and welfare regulations, because Regulation 18 of those regulations is headed doors and gates and provides certain things about doors and gates. So the defendant argued that that must mean that doors don't fall within the provision and use of work equipment regulations. Thus, if a faulty door can't be within the jurisdiction of PURE, it would be illogical and wrong for doors to fall within the 1969 Defective Equipment Act definition. And the court's analysis was firstly based on an interpretation of the words of the Act, unsurprisingly. The court held that the words could possibly expand what equipment might mean, but not restrict the ordinary meaning of equipment. However, none of the words in Section 1.3 of the 1969 Act are particularly apposite to incorporate a reference to doors, because Section 1.3 defines equipment as any plant or machinery, vehicle, aircraft, and clothing. Was the door plant and machinery? The judge grappled with that and considered that the words plant and machinery incorporate an element of production, something being used in the course of creating what the employer produces, and that didn't apply to the door. There are pretty obvious difficulties with describing an ordinary door in an office building as an equipment, because it can't really be said. In the context of this case, for example, the judge said it couldn't be said that the door was somehow part of the process of providing legal advice, whereas a legal textbook or a computer or a telephone might be part of providing legal advice. And secondly, the judge did also conclude that it was relevant that the equipment regulations and the workplace regulations, they still remain in force, obviously, despite the provisions of error. They are still regulatory guidelines, and the regulations potentially impose criminal sanctions on the employer for breach. And so the distinctions between the regulations, and certainly in the sense of the defendant's argument in relation to that there should be a lack of overlap between the regulations, the judge considered that to remain very important, and accepted the defendant's proposition that a number of other previous high authorities had established that you should generally interpret statutory regulations wherever it's possible to do so, so that they don't include an overlap between each other. Thus, the door in the office was not equipment within the meaning of the 1969 Act. And notwithstanding it being only a county court judgment, it's useful to read, I think, for the full arguments about the interplay between the regulatory duties which still exist and the extent to which they inform the scope of common law and negligence. And that is, of course, the battleground really in most employer liability cases now. Moving on to a case which deals with a number of RTA insurance and perhaps illegality principles. Dormer and Wilson is interesting, I think, for 3 points. Firstly, in relation to the insurer's liability for injured passengers in a stolen vehicle case, because as you'll recall, the Road Traffic Act it excludes an insurer's liability to an injured passenger where that passenger has got knowledge that the vehicle has been unlawfully taken. Secondly, it's interesting in relation to what it says about pillion passenger exclusions in motor insurance contracts. And thirdly, it deals with the illegality defence in relation to joint enterprise dangerous driving. So those 3 points arise out of these facts. The claimant is, unsurprisingly, a pillion passenger and on a stolen motorcycle. The motorcycle's being driven by his uncle. Both of them, the claimant and his uncle, are in their young teens. His uncle is, in fact, only 1 year older than the claimant. And the motorcycle driven by the uncle runs a red light, and the claimant sustains some serious injuries, brings a claim against his uncle. But of course, his uncle was uninsured and of no financial means. So the claimant also claims against the insurer of the motorbike, um, under the RTA as the insurer responsible to the claimant as an injured third party. And in the alternative, contends that the MIB are liable under the uninsured drivers agreement. So essentially, the arguments are advanced by the second defendant, and that's the insurer. And the second defendant argues that the claimant had either actual knowledge or blind eye knowledge that the motorbike was a stolen or unlawfully taken vehicle, and that would exclude their liability. Now, the test for that, knowledge as to whether the vehicle was unlawfully taken, is one that requires either actual knowledge or blind eye knowledge rather than constructive knowledge. So blind eye, as it sounds, meaning the knowledge required for the exclusion of the liability is where the passenger either absolutely does know, or does have information that leads to the conclusion that the vehicle is unlawfully taken, or has blind eye knowledge, so has suspicions, but deliberately refrains from asking questions so as to not come to know that the vehicle has been unlawfully taken. And interesting, on an assessment of the particular facts of this case, the court determined that the claimant didn't have actual knowledge and didn't have blind eye knowledge that his uncle had stolen the motorcycle. The claimant was found to be a streetwise young lad, but with a certain naivety about his uncle cousin. The uncle being, as I say, just about a year older. He had a lot of trust in him. And also, it was found as a fact on the witness evidence that he hadn't asked about the provenance of the motorcycle at all, because his mother had brought him up not to be nosy and not to ask people questions. That was accepted as the factual reality by the court. So no knowledge for the exclusion in relation to stolen vehicles to work against the claimant's claim. Moving to the second reason that the case is interesting, the court held that the RTA insurance policy that was in force in relation to the vehicle had a pillion passenger exclusion, but that was found to be of no effect against the innocent passenger because of section 148(2)(c) of the Road Traffic Act, that restricts liability by reference to the number of persons that a vehicle carries. It was an attempt to do that, and section 148 modifies any insurance contract to invalidate exclusions that would otherwise restrict coverage under the policy that's required under compulsory insurance provisions. So on both those points, the decision demonstrates the quite protective approach that interpretations in the cases recently have taken to ensure that third-party coverage remains available to an injured passenger, regardless of contractual restrictions. Thirdly, and in relation to the operation of the defence of illegality, the court had to address multiple potential illegality defences raised by the defendants. There was an alleged joint enterprise in dangerous driving. There was causing the use of a vehicle without insurance, and the claimant allowing himself to be carried in a stolen vehicle. But of course, the illegality defence in relation to the stolen vehicle point fell away because the claimant had no knowledge that it was stolen. The court found that there hadn't been a joint enterprise between the claimant and his uncle in relation to joyriding. And, for example, the claimant hadn't encouraged his uncle to drive faster or to dangerously drive through the red light. So the claimant recovers. I mentioned this next case. It's very recent. It's only tangentially related to personal injury law, frankly. But because we were just looking at the defence of illegality, you'll recall about 3 weeks ago, the Supreme Court gave its decision, or handed down its decision, in Lewis Ranwell. Quite sort of notorious facts in relation to the underlying factual matrix is that the claimant was making claims against a number of the appellants, and his claim was for their negligent failures to provide him with a mental health assessment, which would have led to him being admitted into hospital. And if he had been admitted into a hospital, he would thereby not have killed three men. And so he sought compensation, or has been seeking compensation, I should say, for the consequences of himself killing those men. The compensation being for his compulsory detention and an indemnity against the claims from the victims' families that were anticipated. And importantly, he was initially thought able to do that because at his criminal trial he was found to have carried out the killings, but he was found not guilty of murder by reason of insanity, and so therefore he did not have a criminal responsibility for the murder of these men. And the High Court, upheld by the Court of Appeal, had dismissed the defendant appellant's attempts to strike out the claims on the basis of a full illegality defence. But the Supreme Court has reversed those decisions effectively and applied a policy-based framework or view in relation to the question of illegality. And you'll recall the case of Patel and Mirza, which adopted effectively a policy-based framework to assist the question of illegality, sort of balancing the removal of a claim in relation to, on the other side of the coin, the public interest or the importance of upholding faith in the judicial system, so that sort of people who have done bad things, put bluntly, aren't rewarded. And the Supreme Court found that even in the circumstance of this case, where there was an absence of criminal liability, the conduct was unlawful conduct. And so the illegality defence still applied. And certainly the unlawful conduct was of the most serious degree imaginable. And the unlawful conduct was central itself to the losses that were being claimed in the civil claim. So for those reasons, that's sort of about I think the causative effect of the unlawful but not criminally liable conduct, which founded the claim for the damages, overlied upon the very strong public policy reasons for not permitting the claim, means that the Supreme Court's decision has overturned the High Court and the Court of Appeal in relation to illegality. Moving to more generally applicable and certain sort of practice areas that we encounter very often, looking at a Highways Act claim, Karpasitis, and 2 points to extract from this, really. Firstly, in relation to Section 41 and the ordinary use of a highway, and secondly, in relation to the Section 58 defence and how one might assess highway inspectors' witness evidence. The factual background is that the claimant was cycling alongside the A10, so a relatively major road, a dual carriageway, and the path is separated from the road by a grass verge. As the claimant cyclist comes along alongside a jogger on the path, he overtakes the jogger by cycling over the grass verge and encounters a hole and sustains serious fracture injuries. Of course, the duty under Section 41, as we are very familiar, is to maintain the highway that's maintainable at public expense, and it's a duty owed to all users of the highway, i.e. the ordinary traffic of that neighbourhood at any time. And Section 58 is, of course, the special statutory defence, if it can be shown that the authority has taken such care as in all the circumstances was reasonably required to secure that that part of the highway was not dangerous for traffic. So the first instance decision dismissed the claim. The judge found that the grass verge was indeed part of the highway and it was indeed in disrepair, so Section 41 breach, but the Section 58 defence was established by the defendant. And both of those decisions were appealed, the claimant appealing the second part of the decision and the defendant appealing the first part of that decision. So on that question as to section 41, did cycling on the verge constitute ordinary traffic for the purposes of the path that was the highway in question? Factually, these facts were important. The local authority knew that cyclists used that part of the path, even though it narrowed down to just a walking track. The whole track was effectively marked as a cycle path, a cycle route on a map that had been promulgated by the local authority, a local sort of cycling routes map. And where the path had been wider before the place of the accident, it was signposted as a shared use path. It got to a bridge, and then the use was thought to change, and it became a narrow walking track. But there were no signs to denote that change of permitted use. And so the Court of Appeal determined that it was reasonable to cycle on the verge where the highway authority had actively encouraged a particular use through some signage earlier on the path and through the map that was in existence, and where the local authority had failed to mark where that designated use ends. So the physical constraints of the path, it was perfectly reasonably necessary for a cyclist to use that adjacent area to pass a pedestrian. And so it's another one of the cases where the local authority's duty is owed beyond the formal surface of the highway or even the footway. And the second interesting point in relation to the Section 58 defence, of course, the local authority had succeeded on that at first instance. It had established certain documents that purported to show that the inspection immediately prior to the accident had not identified the defect, and i.e. the defect hadn't been present upon that inspection. However, the highway inspector didn't give any oral evidence because he'd retired. And on an assessment of the factual evidence at the Court of Appeal, the finding on the Section 58 defence was overturned because of effectively deficiencies in the judge's fact-finding exercise. And the assessment of the evidence was in fact pretty stark, because the claimant had obtained through disclosure GPS evidence which showed that the inspector had driven along the A10 for 10 minutes and stopped his vehicle once for 3 minutes at a place not by the defect. So the inevitable inference was that the inspector hadn't conducted a walked inspection of the relevant place at all. And as against that, the inspector's witness statement saying that he had done a walked inspection should have been treated as manifestly incredible. And he, of course, wasn't cross-examined on it. And also of general application, that the Court of Appeal stresses in this case that as a general principle in relation to the approach to evaluating a witness's evidence, you should start by looking at contemporaneous documents, especially those that are produced from an impartial source, before then considering what the witnesses have to say about them. And the first instance judge had effectively just preferred the signed witness evidence over the other disclosed materials. Moving to public liability cases and the category of cases that we've seen over the past few years that I've given this talk in relation to effectively activity duties in relation to organised events. And the first case is useful and interesting in relation to the application of the Social Action Responsibility and Heroism Act, as well as thinking about duties owed by a volunteer organisation. The claimant in this case is injured while cycling in a time trial organised by a voluntary cycling club. And common road traffic accident circumstances, the claimant's struck by a car that's coming in the opposite direction but then turns right across the cyclist path. Ultimately, the driver's insurer admits liability, but the driver's insurer brings a contribution claim against the cycling club. And I think that the points to extract from this case are the levels of, or rather the scope of the duty and the standard of care that are required in the context of voluntary organisations. Firstly, unsurprisingly, the court concluded that it was just and reasonable to find that the voluntary organisation owed a duty of care to carry out a risk assessment, and the risk assessment in particular to assess the risk of coming into contact with a negligent driver. The scope of the duty that was imposed on the club in relation to conducting such a risk assessment was a duty to take reasonable care to identify relevant material hazards, assess that level of risk, and identify reasonable mitigation measures within their power to mitigate. But in assessing the standard of that care, the standard was to be one of a reasonably competent and reasonably informed voluntary organisation, i.e., not a professional event organizer. The risk assessment that was the subject of this accident, the one immediately before the accident, had categorized the junction where the accident happened as a low risk junction, despite the fact that there had been a road traffic incident there 2 years prior during an organised race, which had at that earlier period resulted in an additional warning sign being put up. But that additional warning sign wasn't there on the date of this index accident. The court considered that the categorization of the hazard at that junction as low was suitable and sufficient, and that there was no need for the additional sign there. The court determined that the placing earlier on of the additional sign at the junction was additionally and not necessarily reasonably required notice to other road users. And in fact, it was an element in the case of how evidence as to how carefully the voluntary organisation had previously considered their duty, but it wasn't necessary or required to satisfy the standard of care that it was imposed within the scope of their duty. And so influential in that decision was, as I say, the provisions in the Social Action Responsibility and Heroism Act 2015. And Section 2 of that Act requires the court to have regard to whether the alleged negligence occurred when a person was acting for the benefit of society or for its members. And Section 3 requires the court to have regard to whether the person demonstrates a predominantly responsible approach towards protecting the safety of or other interests of others. And the Compensation Act of 2006 also similarly applied. And in this case, the court emphasised that the standard of care placed upon voluntary organisations shouldn't be so high that it would discourage their activities. And there was also a causation point in this case as well. So if there had in fact been a breach by failing to put up a bigger or additional or earlier sign, excuse me, the court found that didn't make any difference because, of course, we had a defendant driver in this case who, prior to reaching the point of collision, hadn't seen or hadn't heeded road marshals that had been out and hadn't heeded signs that were on approach to previous junctions. So the court considered that none of the pleaded breaches would in fact have been causative. Also, excuse me, a planned activity. And this is the type of luxury holiday that most of us won't be able to afford. A man who is a regular purchaser of McLaren supercars was on an experience holiday driving snowmobiles through ice. And he was following a guide on a track through a wood. And this was part of the activities that McLaren, who he purchased his supercars from, had organised for him or had used an agent to organise. And he lost control and he hit a tree. In the immediate aftermath of the accident, he quite effusively conceded he'd been at fault, and he offered to pay for the damaged vehicle. And the claim that later it emerged after presumably he'd got into contact with lawyers relied on the package travel and link travel arrangements regulations. And they applied to the contract between McLaren and this gentleman because Regulation 15 of those regulations makes an organizer liable for the proper performance of the contract by their suppliers. So it was an implied term between in the contract between the claimant and McLaren that the defendant would exercise reasonable care and skill in providing the snowmobile safari. The standard of care was the local Finnish standard, and there were effectively three issues in relation to breach, or three main issues. Firstly, the whether the defendant had breached the standard of care when giving the briefing on how to operate the snowmobile, and whether switching the mode of the snowmobile, which happened partway through the course, was a breach, and whether the defendant had failed to guide the claimant around the track safely, because at one point the guide snowmobile had got out of sight of the claimant. Now, it was found that during the briefing, the guide had covered all the relevant matters, including steering and braking and turning and proper use of the throttle, and had particularly instructed the claimant to release the throttle when he was slowing down, and when turning left, he should pull down with his left hand and not push up with his right hand, because there would be the danger of accelerating and hitting the throttle if he pushed with his right hand. And on the local standard evidence of the Finnish law experts, it was also agreed that the decision to change the mode of the snowmobile could have been made by a guide for a beginner. That was appropriate by the local standards. And I think particularly influential in the court's decision in relation to the local standards, they noted that the guide, of course, wasn't guiding a 17-year-old new learner driver, but this claimant was a mature supercar driver, a jet ski aficionado. Query how similar that is to the snowmobile. But he'd ridden very confidently on previous snowmobile rides. He'd asked for more speed, etc., etc. It was found that the guide had got too far ahead of the claimant and not turned around to check. However, on the findings of fact, the pleaded claim wasn't made out on the mechanism of the accident at all, because it wasn't caused by being out of sight of the guide, or by the claimant going too fast because he was trying to keep up with the guide who'd got too far ahead. But it was caused by the claimant accidentally using his throttle when he was trying to turn, because he'd failed to follow the specific instructions that had been given to him. And I think in a more general sense, the judgment's useful because it re-emphasizes the significance of the contemporary records that were made at or shortly after the incident. And when it came to deciding matters of fact in relation to the slightly conflicting evidence, the court preferred the records that had been independently made by the guide, and what the claimant had said to hospital doctors, and the claimant's own agreement that he'd overlooked what he'd been told, or that he'd wanted more speed, etc., rather than what the claimant later said in his witness statement and at trial. And we've got a few more minutes, so coming to the final case to look at, which is a procedural case, as I highlighted earlier, Perrin and Walsh, and essentially a case about balancing the probative value against the prejudice or ambush to the claimant of some surveillance evidence. But it's not a particularly comfortable case for the surveillance group, but it's also not a particularly comfortable case for claimants being faced with video surveillance evidence, which really does have some probative value, because there's a pretty high bar for the exclusion of such evidence. If you're not familiar with the particular facts of this case, there's a serious injury, multiple fracture injuries, psychiatric and possible TBI injury being claimed for, and the surveillance agents are contracted to carry out covert surveillance over about a 2-year period of time. By the time the defendant has decided to deploy that evidence, and the court had to determine their application for permission to rely on it. It was clear that the surveillance evidence was supportive of the defendant's case, but that surveillance that was entirely supportive of the claimant's case had been deliberately excluded from the edited footage, and that signed witness statements, the production statements from the surveillance operatives, were just untrue because they stated that no such footage had been excluded, and other deficiencies. So the logs for surveillance included dates on which surveillance just didn't occur, etc., etc. And so the decision demonstrates balancing that procedural misconduct against probative value. And the starting point, as we'll have come across in these applications, is really from language from the case of Rawle and Hume. So where the video evidence is sufficient to undermine the case of the claimant to an extent that substantially might reduce their award of damages, then it's usually going to be in the overall interest of justice to require that the defendant can cross-examine on it, as long as it's not an ambush. And in the balance, in particular, of the very significant failings procedurally and worse than failings in this case, the court reflected back on the case which you might remember of Jones and Warwick universities. So wherein surveillance operatives effectively tricked their way into the house of a claimant and surveyed her there, and thus infringed, obviously, Article 8 rights to private life, etc., etc. And in that case, Lord Justice Walford held that the failings procedurally have got to reach a threshold of being so serious as to justify the exclusion of otherwise probative evidential material. And in this case of Perrin and Walsh, the court wasn't satisfied that the failings, as serious as they were, met the threshold for excluding what was otherwise probative material. So while courts won't tolerate very serious procedural failings in surveillance evidence gathering, I think it is fair to say that the case law shows the threshold for exclusion is still pretty high. That concludes the slides. I think there's a question, if I can see that. Someone is asking to get a copy of a particular case. I'm sure we can accommodate that. So what it remains for me to do is to say thank you very much for everyone's time this afternoon. As I say, you'll shortly receive the slides, and I'm sure I can send a copy over of Karpasitis. If you have any other questions, however, please feel free to email me or call into chambers on the numbers that you've got there. Great. Thank you very much. Good afternoon and have a good evening.